Summarily, we move next to Bedjarmo. The issue in that case was whether to recognise at common law the appointment of a trustee in bankruptcy under a judgment of the Russian court.
Hang on, which case is that?
Bedjarmo. Start with Mr. Justice Snowden's decision.
Oh, yes.
Was. It's A2, Authorities Bundle 2, tab 28. And the foreign office holder in that case was, in the usual way, seeking recognition in order to access assets in the jurisdiction. We start at paragraph 107 in Mr. Justice Snowden's judgment. His Lordship begins by explaining why recognition of the foreign office holder under the cross-border insolvency regulations was not possible because the bankrupt did not have his centre of main interests or any establishment in Russia. His Lordship then explains at paragraph 111 why the statutory scheme for recognition under section 426 of the Insolvency Act was inapplicable because Russia is not a relevant state for the purposes of that scheme. So what that left was common law recognition as the only potentially available route. And Mr. Justice Snowden turns to the common law principles at paragraph 113, and he begins with what, in my submission, is a very important insight. He says, most of the common law authorities and commentaries to which I have referred do not deal with recognition in quite the same way as the cross-border insolvency regulations, which focus on recognition of the foreign representative or office holder. Instead, they treat recognition as a question of recognition of, by the English court, the foreign court order commencing bankruptcy proceedings. And the common law in this context, in my submission, proceeds on exactly the same principle that we have seen in the context of judgments in rem and marital status. If a party wishes to assert a status deriving from a foreign bankruptcy order, the party must persuade the English court to recognise that order in line with domestic principles. Mr. Justice Snowden turns to consider those principles at paragraph 115. He records as common ground that the only basis upon which the Russian court's order could be recognised is if the debtor had submitted to its jurisdiction. His Lordship considers that issue in the paragraphs that follow, and at paragraph 130, His Lordship concludes that the debtor had submitted, so the Russian order was in principle entitled to recognition. Then at 132 and following, he considers bars to recognition and identifies at paragraph 133 well-established grounds for non-recognition: fraud, natural justice, and public policy. And he ultimately concluded, on a summary basis, that none of those bars applied. The case then went on appeal to this court, which allowed the debtor's appeal on the basis that his allegations of fraud and forgery raised matters for trial rather than for summary determination. This court's judgment is in the third authorities bundle, still in the second authorities bundle, at tab 32. I don't ask the court to turn it up because it doesn't shed any further light on the applicable principles in relation to this appeal. What it did deal with was the consequence of recognition, whether that would lead to the trustee accessing movable property, which was the view of the majority, or immovable property as well, which was the minority view of Lord Justice Arnold. But that issue doesn't matter for the purpose of this appeal.
That doesn't really matter for present purposes, does it?
What matters for the purposes of this appeal is that both this court and Mr. Justice Snowden, as he then was, were applying a recognition analysis, recognising the well-established bars to recognition, and in this court, recognising that it was necessary for there to be a trial of the allegations of fraud that were made in relation to the Russian proceeding. So drawing the strands together, we say the case law drawn from these various contexts, property cases, the marital status cases, and the office holder cases, provides powerful support for our argument that where a party asserts in an English court a right or status based on a foreign judgment, she can only do that if the foreign judgment is entitled to recognition in line with domestic principles. And there is no principled distinction for treating the appointments of directors to a foreign company under a foreign court's order any differently. I turn then to the second source from which we derive support for our court case, and that is the law on the Foreign Act of State doctrine and its limits. And this is important to our argument because it contextualises where Williams and Humbert's fits in and why it is irrelevant in this case. And where Williams and Humbert fits in is as part of the Foreign Act of State doctrine rule that the English court does not generally question foreign legislation. What it sheds absolutely zero light on, nothing whatsoever, is the English court's approach to the recognition or non-recognition of foreign judgments, an issue which proceeds on fundamentally different principles, as Lord Lloyd-Jones explains in the Venezuela case. Can we go to that case? It's tab 30 in the same authorities bundle your Lordship and your Ladyship should have open. Lord Lloyd-Jones gives the judgment with which each other member of the Supreme Court agreed. We see at paragraph 1 that Lord Lloyd-Jones explains that the appeal raised, his words, fundamental issues concerning the recognition of a foreign head of state, Foreign Act of State doctrine, and their interrelationship. The context in which those fundamental issues arose is set out at paragraphs 2 and 3 of the judgment. Can I ask the court to read paragraphs 2 and 3? As in the present case, the issue before the Supreme Court was who was authorised to represent a foreign corporate body in relation to its assets in England. In the Venezuela case, the foreign corporate body was its central bank, and its assets were claims in a London arbitration, cash held in an English bank, and gold held by the Bank of England. In the present case, the foreign corporate body is Koza Altin, and the assets in question are its shares in an English company, Koza Ltd. But the same core issue arises as to who is authorised to represent the foreign corporate in relation to its assets in this jurisdiction. Now, there were two main issues on the pleadings in the Venezuela case. The first of those issues was the recognition issue. That was the question who the English court should recognise as the president of Venezuela, Mr. Maduro or Mr. Guaido. And that turned on the one voice principle under our constitution. And that does not concern the court on this appeal. The second issue, which does concern the court on this appeal, is the Act of State issue. That was the question how far the English court could investigate the validity of appointments to the board of the Venezuelan Central Bank under legislative and executive acts in Venezuela. And the part of Lord Lloyd-Jones's analysis on the Act of State issue that is of particular relevance is the distinction he draws between foreign legislative and executive acts on the one hand and foreign judicial acts on the other. And it was necessary for Lord Lloyd-Jones to consider judicial acts in Venezuela because part of the Maduro board's case was that Mr. Guaido's acts of appointment had been held to be null and void by the highest constitutional court in Venezuela, the STJ, as it is identified in the judgment. And Lord Lloyd-Jones went on to hold that the Foreign Act of State doctrine had no application to that issue. It instead raised a question about the recognition of those Venezuelan judgments, with the consequence that the allegations of corruption which the Guaido board advanced as a reason for not recognising those judgments would need to be tried out in the commercial court. Now, if we can move forward to paragraph 110 in the judgment. We see there Lord Lloyd-Jones's ultimate conclusion on the recognition issue. I mention that because it provides the context for the Act of State issue. In short, it was Mr. Guaido who won the recognition contest and Mr. Maduro who lost. And against that background, we turn to the Act of State issue dealt with at paragraph 111 of the judgment and following. His Lordship begins by explaining that a consequence of his conclusion on the recognition issue is that President Guaido's appointments as public officials were to be regarded as sovereign acts of the Venezuelan state. And so the question arose, how far the Foreign Act of State doctrine prevented the English court from investigating the validity or otherwise of those sovereign acts. And at paragraph 112, Lord Lloyd-Jones notes that the Foreign Act of State doctrine is notorious for its difficulty and have been the subject of recent Supreme Court authority, Belhage and Straw, in which divergent views had been expressed. And pausing there, we invite the court to keep in mind that in the Venezuela case, the Foreign Act of State issues had been tried as preliminary issues with the benefit of pleadings and expert evidence. And that was the procedural context in which the appeal came before the Supreme Court. It was not a case like this one, in which the question is whether there are serious issues to be tried. If we return to Lord Lloyd-Jones's judgment, at paragraph 113, he refers to Lord Neuberger's judgment in Belhage, which he took to contain the ratio in that case, and identifies on the basis of it 4 potential rules as comprising the Foreign Act of State doctrine. It is the first and the second rule that were in issue in the Venezuela case. Can I ask your Lordship and your Ladyship to read subparagraphs 1 and 2?
This is the case that really decides once and for all that Rule 2 exists and should be applied in its full force.
Indeed.
It having been argued by the Maduro board that it was narrower or more obscure or only applied in certain circumstances, etc., etc.
Indeed.
He goes on to say, doesn't he, well, the time has now come to come out and say that this rule is not just about legislative acts, it's about executive acts as well.
Indeed. And as you, my Lord the Chancellor observes, that was the main terrain of the argument before the Supreme Court as to the existence and scope of Rule 2.
Yeah.
But it is important to note what Lord Lloyd-Jones says about the limitations of the Foreign Act of State doctrine. And for that, we need to go to paragraph 136.
136.
136. And Lord Lloyd-Jones there refers to the observations of Lord Justice Ricks in this court, in the UCOS case. And we draw attention to two of these limitations or exceptions.
Mm-hmm.
The first is subparagraph 2 over the page. The doctrine will not apply to foreign acts of state which are in breach of clearly established rules of international law or are contrary to English principles of public policy, as well as where there is a grave infringement of human rights. Now, I will come back to this when I deal with my learned friend's respondent's notice points. But we rely on this exception if and insofar as we need to challenge the Turkish legislative and executive acts in this case.
And your primary case is that everything relates back to the Sewell judgment.
Indeed.
And if you're right about that,
Indeed.
then we'll come on to what Lord Lloyd-Jones says about foreign judgments in a moment. But if you're right about that, then this particular point doesn't matter.
Indeed.
But this is really a fallback position. If you're wrong, you say that the relevant legislation and the relevant executive acts are open to criticism.
Indeed. So our primary case is that we don't seek to challenge at all legislative or executive acts. We seek to challenge the Sewell judgment. It is only if that primary case is rejected that we make the alternative case that the Turkish legislative and executive acts are themselves open to challenge on public policy grounds.
Okay.
As my Lord the Chancellor says, we never get to the alternative case if we're right on the primary case. Now, the primary case is the limitation or exception identified at subparagraph 3. Judicial acts will not be regarded as acts of state for the purpose.
Which one?
I'm so sorry, my Lord, I spoke over.
Which, 3, yes, sorry.
I'm on subparagraph 3.
Yeah, I got you, yeah.
Judicial acts will not be regarded as acts of state for the purpose of the Act of State doctrine. And the basis for that is the passage I showed you in Altimo and Lord Justice Ricks' analysis in UCOS. And we see that analysis quoted in a later passage of Lord Lloyd-Jones' judgment. Now, if we move ahead to paragraph 153, we come to the section that's entitled The Judgments of the STJ. And Lord Lloyd-Jones says that it might be thought that once President Guaido had been recognised as Venezuela's president, as he was in England, that Rule 2 of the Act of State doctrine would prevent the English court from investigating the validity or legality of his appointments because they were sovereign acts of state. However, Lord Lloyd-Jones explains that that was to overlook the STJ judgments, which had declared Mr. Guaido's appointments null and void as a matter of Venezuelan law. And the argument that was advanced in opposition to that by the Guaido board was that the English court should give priority to the legislative and executive acts, and it should effectively ignore the judicial acts. And Lord Lloyd-Jones holds that that is wrong. In his lordship's view, what the English court should do in the ordinary way is apply its domestic principles on recognition of judgments. And if, applying those principles, the STJ judgments were entitled to recognition, the consequence of that would be that the appointments by the Guaido presidency were void. And so the issue ultimately collapsed into the question whether the STJ judgments were entitled to recognition. And that was an issue for trial, given that the Guaido board advanced allegations of corruption and so on as bases for non-recognition. And if we can go ahead to paragraph 157, Lord Lloyd-Jones identifies the principle. He says, although judicial rulings of a foreign state are manifestations of state sovereignty, it is now clear that they do not themselves attract the operation of any rule of foreign act of state applicable in this jurisdiction, and as a result are not entitled to the deference which may be shown to legislative and executive acts of a foreign state. So much was established by Lord Collins, JSC, delivering the judgment of the Judicial Committee of the Privy Council in Altimo, AK Investments. Your Lordship and your Ladyship sees there the passages I took you to earlier. Then moving on to 158, Lord Lloyd-Jones observes that Lord Justice Ricks built on this foundation in UCOS, which held to be justiciable the issue whether judicial acts had been part of a campaign waged by the Russian state for political reasons against the UCOS group and its former CEO. Of course, our pleaded allegations which it is conceded are matters for trial, are exactly the same as the allegations that were being made in UCOS. Lord Lloyd-Jones goes on to say, this difference of approach does not reflect any hierarchical inferiority of judicial acts, but rather reflects a shared understanding of how courts should behave under the rule of law. As Lord Mans JSC put it in Belhage and Straw, if one believes in justice, it is on the basis that all courts will or should subscribe to and exhibit similar standards of independence, objectivity, and due process to those with which the English courts identify. And the judge found, and it is conceded in this court, that there are serious issues to be tried as to whether the Sewer judgment complied with those judicial standards. Can I ask the court to read 159, which endorses the analysis of Lord Justice Ricks in UCOS, explaining the rationale for the difference of approach in relation to recognition cases, and note in particular the endorsement at the end of the passage of what the Master of the Rolls said in Pemberton and Hughes. And if we move ahead to 161, Lord Lloyd-Jones begins to pull the threads together. He says, there is therefore no rule requiring an unquestioning acceptance by courts in the United Kingdom of the validity or legality of a foreign judgment. Rather, the status of a foreign judgment is left to be determined in accordance with domestic rules on the recognition and enforcement of judgments. Then over at 170, Lord Lloyd-Jones says the focus of the present case therefore shifts to the status of the judgments of the STJ on which the Majuro Board relies. These judgments do not themselves attract the protection of any act of state rule, the question becomes whether, and if so, to what extent they should be recognised or given effect by the courts of this jurisdiction. These are matters which fall outside the preliminary issues and which have not been addressed in argument before us. It will accordingly be necessary to remit this issue for further consideration by the Commercial Court. One matter, however, is clear. Courts in this jurisdiction will refuse to recognise or give effect to foreign judgments, such as those of the STJ, if to do so would conflict with domestic public policy. In our submission, the focus of the present case is in substance identical. It is likewise the recognition or not of a foreign judgment, the sewer judgment, and as an aspect of that, the core factual question whether to recognise it would conflict with the English court's public policy.
Well, it's interesting that he then goes on to say that part of that consideration is the fundamental point, that is the fundamental one voice doctrine. So actually, he's bringing back in the foreign acts of state doctrine to that extent.
Indeed.
Or he's directing that that's something that the Commercial Court will have to consider.
Indeed, and part of my argument, if this case goes to trial, will be that exactly the same analysis should apply if the court concludes that the sewer judgment is contrary to English public policy. Having reached that conclusion, it would be incoherent for the English court to go on and give effect to legislative and executive acts that were premised on the sewer judgment being valid. Putting that point in a slightly different way, it would be contrary to public policy for the purpose of the exception to Rule 2 to treat as valid and effective in this jurisdiction foreign legislation and executive acts premised on a corrupt judgment. But of course, as my Lord the Chancellor observes, that's my alternative case, and we only get there if I need to, contrary to my primary case, go further than the sewer judgment. So that's our core case. I come next to the second part of my submissions, which is to develop the grounds of appeal. We have 4 grounds of appeal. They each address different strands in the judge's reasoning, but their common theme is that the judge erred in failing to apply the core principle that I developed in the earlier part of my submission. Our first ground is that the judge erred by treating the authority issue as a choice of law question determined by Turkish law, rather than a question dependent on the recognition or not of the sewer judgment in line with English principles. Let me first identify the relevant passages in the judgment. If the court can take up the core bundle, we're behind tab 11, and we pick up the judge's reasoning here at paragraph 88 on this aspect. And the judge first records one of my learned friend's preliminary submissions in answer to our case. So 88. Your learned friend had submitted then, as he submits now. This is a basic principle of private international law, that because Koza Altin is a Turkish company, Turkish law governs the constitution of its board of directors, and whether or not they have been validly appointed, a proposition with which Mr. Atkins did not disagree, Turkish law recognises the status of the individual defendants to act on behalf of Koza Altin, including by procuring it to exercise its rights as a shareholder. The evidence is clear. Judicial and administrative decisions in Turkey are valid, effective and binding until set aside, which has not happened with the decisions that have led to the appointment of the individual defendants in this case. It follows that the English court is not being asked to rule on a point of law, it is being asked to determine that it should not recognise what has happened as a matter of Turkish law, notwithstanding that Turkish law governs the substantive issue with which the 2016 and the 2021 proceedings are both concerned. That's my learned friend's argument, the choice of law analysis that was urged on the judge. The judge adopts that analysis at paragraph 99 of his judgment. In the second part of the paragraph, on the 5th line down, can I ask your lordships and your ladyship to read, beginning from so far as the status of the individual defendants as directors of Koza Altin are concerned, in the middle of the paragraph. I'll address the reliance placed on Williams and Humbert under our ground 3. I'm just addressing at this stage under ground 1 the judge's approach in treating the authority issue as a choice of law question. The court will see the same strand of reasoning at paragraph 114, which is the judge's ultimate conclusion on serious issue to be tried, and the same choice of law reasoning at 170, which is the judge's ultimate conclusion on the strikeout application. And we respectfully submit the judge's choice of law reasoning was wrong. The issue facing him was not a choice of law question.
So which paragraph is that again?
114, the final conclusion on serious issue to be tried, and 170, the final conclusion on the strikeout application. The judge says there, in my view, the answer to the question which the strikeout application raises is simply that Turkish law governs the issue of authority. We respectfully submit that is simply wrong. What governs the issue of authority in this case is whether or not the sewer judgment is entitled to recognition. And one can illustrate that point by considering the authorities that I showed the court earlier. Take Castries and Imri. One might approach the issue in that case by treating it as a choice of law question, title to movable property. Apply French law to that question as the lex situs, and conclude that because there was a French judgment ordering the sale of the property, which had not been set aside, that determined the issue. Mr. Justice Keating, as we have seen, approached the case in much that way, treating it as a choice of law issue and resolving it on the basis of what he inferred to be French law. But that was not the approach of the majority and not the approach of the House of Lords. They all treated it as a recognition question. And one can perform exactly the same exercise in relation to AK Investments, von Lorang, the office holder cases, and also the Venezuela case. The Central Bank of Venezuela was a legal person existing under Venezuelan law. The essential issue for the English court was who should be recognised as its directors for the purpose of giving instructions in relation to assets here. If you approach that as a choice of law question, the answer is straightforward. You apply Venezuelan law. And as a matter of Venezuelan law, as settled by the Superior Court of Justice, the STJ, the appointments of the Guaido board were a nullity. But none of the judges in the Venezuela case, not Mr. Justice Tier, not this court, not the Supreme Court, none of them treated it as a choice of law question. They all treated it as a recognition question. And the approach in all these cases reflects a simple principle, which we say is compelling. Where a party asserts in England a right or a status derived from a foreign judgment, she must show that the judgment is entitled to recognition in line with domestic principles. Otherwise, the judgment can have no legal effect in our system.
Sorry, could you repeat that a little more slowly?
I'm so
it's quite
sorry,
an
my
important point.
Yes, the principle is this. Where a party asserts in England a right or a status derived from a foreign judgment, they must show that the judgment is entitled to recognition in line with domestic principles.
Thank you.
Otherwise, the judgment can have no effect in our legal system. And that principle is not only borne out by the various authorities I have shown the court, the in rem cases, the marital cases and so on. It's also borne out by the foreign active state case law and the limits authoritatively identified now in the Venezuela case. By treating the issue before him as a choice of law question, what the judge allowed to happen was the SUR judgment to have effect in this jurisdiction in terms of conferring on the individual defendants the status of directors, irrespective of whether it offends against English views of substantial justice, and indeed despite the judge having found that it arguably does offend against substantial justice because it is corrupt. And with respect to the judge, the whole approach was wrong in principle, because it all proceeds from the flawed premise that he was concerned with a choice of law question, and he was not. That's ground one. Turn now to ground two. This addresses a further strand in the judge's reasoning, the suggestion that the substantive issue in this case is the disputed rights of Koza Altin as shareholder, and there is no need for the trustees to rely on the SUR judgment in relation to that substantive issue. Let me first identify...
I think you need to repeat that. You are going quite quickly. I know we've got a transcript. It's helpful to be able to take a note.
I'm so sorry, let me slow down.
Heard in saying the substantive rights.
So the second ground is the judge's suggestion that the substantive issue in the case is the disputed rights of Koza Altin as shareholder in Koza Ltd. And there is no need for the trustees to rely on the SUR judgment in relation to that. And we say the judge erred because that analysis was to assume the authority issue in favour of the trustees. If I am right on the authority issue, what my learned friend's clients are doing has nothing to do with the exercise of Koza Altin's rights. It is the usurpation of Koza Altin's rights by individuals who do not have authority from that company to represent it. Let me identify the passages in the judgment where the court will see this substantive issue reasoning. We start with paragraph 64. Can I ask the court to read paragraph 64 in the judge's judgment? And if we move ahead to paragraph 90, records my learned friend's submission on this point. Then 93 to 94 effectively accept that submission. You see in 93, the judge says, the real rights with which this litigation is concerned are rights that Koza Altin has under English law as a shareholder of Koza. The fact that Koza Altin is being encouraged or procured to exercise those rights by persons appointed pursuant to a flawed Turkish law process is neither here nor there so far as English law is concerned, thought the judge. The reason for this is that English law will not in those circumstances be enforcing the flawed Turkish process. It will simply be enforcing the English law right. With respect to the judge, that just begs the issue at the heart of this case.
Doesn't that simply bypass the whole issue of authority?
Indeed. Because before we get to any debate about Koza Altin's rights, there is the issue, are the clients of alerted friends authorised to exercise those rights in this jurisdiction or not? We say they are not. And the court must grapple with that issue before it gets to decide what the substantive rights of the company are. And the judge recognised this point in his analysis on Gateway. Because in his analysis on Gateway, the court will see this at paragraph 128, he rightly recognised that our claim is a claim to restrain the trustees' acts on the premise that those acts are not authorised by Koza Altin. That's why they're acts in the jurisdiction. But to decide whether that premise is well-founded or not, it is necessary to grapple with the authorities. And with respect to my learned friends, they also beg the authority question in paragraph 31 of their appeal skeleton. The court has that in the core bundle, tab 10 at 85. And they describe this as their first and their fundamental point. They say at 31A,
So which paragraph? 31.
31. They say that the corrupt sewer judgment is not the issue. And at A, because, they say, the rights which Koza Altin is seeking to exercise in this jurisdiction are the rights it has as a shareholder in Koza Ltd.
Sorry, I must be looking in the wrong place, but where should I be looking?
I'm so sorry, it's
Page 85.
tab 10, page 85 in the core bundle.
Sorry, I'm looking at entirely the wrong document. Yeah, thank you.
Your case, it raises a prior question, doesn't it? Your case, it raises the issue as to whether the people who say that they are entitled to act on behalf of Koza Altin are in fact entitled to act. Because if they aren't entitled to act, then the fact that Koza Altin is a shareholder as a matter of English law is neither here nor there, indeed.
Because they are not acting for Koza Altin.
Because if in a sense it's not a foreign law issue at all. If you imagine that an English parent company that's somehow been hijacked, as it were, by a group of rogue directors who don't have authority, there'd be no answer to a case that said, well, these people are not authorised to act on behalf of the parent company. To say, oh, well, never mind all that, the parent company is just a shareholder in the company, and that's the beginning and the end of it.
And that's why this first and fundamental point is just fundamentally wrong. It begs the whole issue in this case. And the same applies to the point made in subparagraph B. It is true, as my learned friends say, the rights of Koza Altin as a shareholder in Koza Ltd are not founded upon any foreign judgment or administrative decision. True, but nothing to the point. And nothing to the point because the whole issue is whether the trustees have authority to exercise those shareholder rights. And that does depend on the sewer judgment. 31C is in part the choice of law argument I've already addressed the court on, and it is otherwise a respondent's notice point that I'll come on to. So that's ground 2, the substantive issue point. Ground 3 is Williams and Humbert. Let me identify the relevant passages of the judgment. We're back in the next tab, tab 11 of the bundle. And we can pick this up at paragraph 95. Can I ask the court to read 95, which helpfully summarises what Williams and Humbert was about. '96 is Mr. Crow's argument that Williams and Humbert was on one view a stronger case because the measures there were expropriatory, whereas on his case the measures in Turkey in this case are temporary measures of control. We don't in fact accept that on the facts, but anyway, that's the argument. And then at 97, Mr. Justice Trower extracts what he took to be the relevant principle in Lord Templeman's speech in Williams and Humbert. This is the proposition that by the time the case came to England, there was nothing left to enforce. The Spanish legislation had done all it needed to do in Spain. And then 98 is where the critical reasoning is. The judge says, this, which is Williams and Humbert, is a slightly different context from the one which arises in the present case, because the rule of private international law said to be offended is enforcement or recognition of a corrupt foreign judgment rather than enforcement of the foreign penal law. But in my view, the underlying principle is essentially the same. And as I have shown the court on the basis of the Venezuela case, the underlying principles are not essentially the same. They are fundamentally different. Williams and Humbert dealt with 2 points, and neither has any relevance to our core case in this appeal. The first point was whether the claims in that case, which were private law claims for company director misfeasance and to recover funds, whether those claims engaged the well-established rule against enforcing foreign penal law. And the House of Lords held that they did not. Because even if the Spanish law was penal, there was nothing left to enforce, as the shares in the relevant Spanish companies had been transferred under the relevant Spanish legislation. So that's the first point. That's got nothing to do with our case. The second point is whether it would be contrary to English public policy to recognise that Spanish legislation. And the House of Lords held that it would not be. I should show the court the passages on this because not all of them are set out in the judgment. Can we take up the first authorities bundle? We're tab 15 for Williams and Humbert. We can turn ahead to page 427 in the report, which is 394 in the bundle. And the court will see against letter F on that page the relevant pleaded case. What the defendants were saying is that the plaintiffs are not entitled to the relief sought or any relief by reason of the fact that the proceedings represent an attempt to enforce foreign law which is penal, or which otherwise ought not to be enforced by this court, and further, or alternatively, that it would be contrary to public.
I lost where you're reading from.
I'm so sorry. I'm on page 427 of the report, which is page 394 in the bundle itself. I'm reading against letter F. sets out what the defendant's pleaded case was. And the court sees there 2 points: enforcement of foreign penal law, I've addressed that, and public policy. And then against letter G, Lord Templeman says that the plea could be justified if English law or international law abhorred compulsory acquisition legislation, but in fact it does not. And then over the page 428 of the report, against letter F, Lord Templeman deals with the rule against enforcing foreign penal law in his conclusion that that does not apply. And if the court can turn over to page 430 in the report against letter E, Lord Templeman refers here to the Russian Revolution cases, Luther and Sager, Princess Paleolga and White. They were cases in which Russian decrees affecting property in Russia at the material time were recognised and not questioned in the English court. Then over the page at 431 against letter C down to E, Lord Templeman says this: these authorities illustrate the principle that an English court will recognise the compulsory acquisition law of a foreign state and will recognise the change of title to property which has come under the control of the foreign state, and will recognise the consequences of that change of title. The English court will decline to consider the merits of compulsory acquisition. And we do not dispute any of that as an accurate and orthodox summary of Rule 1 of the Foreign Act of State doctrine. But what it has nothing to do with, and does not purport to have anything to do with, is the court's approach in cases of foreign judgments.
But he recognised, I mean, we recognise this, doesn't he? And the passage you showed us at 427 at G is really making the point. If English law regarded the Spanish law on compulsory acquisition or any other law on compulsory acquisition as abhorrent in the same way as the Nazi appropriation laws that were considered in Catamol, then the court would have concluded that the plea was a good one on the basis that the English court should not recognise the Spanish legislation.
Yes.
This isn't about a Spanish judgment at all. But what he's really saying is the legislation has taken effect in Spain. The rights are passed pursuant to that legislation, and they simply now have those rights, and they're coming to England to enforce the rights. And therefore, the court isn't being asked to consider whether or not the legislation is abhorrent in some way, because it isn't.
Entirely so. And ultimately what this all is an example of the deferential approach by the English court under Rule 1 of the Foreign Act of State doctrine to foreign legislation. That legislation will be recognised and not questioned, subject
Unless
only.
it's penal.
Unless it's penal. Unless it's well, the penal aspect raises a slightly different point, because the rule is against enforcement of foreign penal law, and the concern in relation to that is where the foreign sovereign comes to the English court in an attempt to enforce their foreign penal law. But when the court is simply concerned with whether or not to recognise foreign legislation taking effect in the jurisdiction of the foreign state, the court ordinarily does so, and it only doesn't when, as my Lord the Chancellor observes, it would be contrary to public policy. But the basic point here is this has just got nothing to do with foreign judgments, which are, in Lord Lloyd Jones's words, simply less impervious to review. Can I deal finally under this heading with what my learned friends say about William and Humbert in their skeleton, we can go to tab 10 in the core bundle, page 86. They say that Williams and Humbert is dispositive of this case. And the court has my submission that it is in fact wholly irrelevant to our court case in relation to the sword judgment, which attracts principles on the recognition of foreign judgments rather than the very different principles in play in Williams and Humbert. And the balance of 32 seeks to support the analogy between Williams and Humbert and the present case. But with respect to my friends, they ignored the critical distinguishing feature. That was a case about recognition of foreign legislation. It has nothing to do with foreign judgments. If we move forward in the same tab to paragraph 46 of their skeleton, they make the point that a public policy argument was run and rejected in Williams and Humbert. That is true, but it was a public policy argument directed at the recognition of Spanish legislation. So it attracted Rule 1 of the Foreign Act of State doctrine and the deference that comes with it. Different principles apply to foreign judgments, which are simply less impervious to review. My lords, my lady, I come next to ground 4. Under ground 4, we say that the judge erred in concluding on a summary basis that we cannot rely, insofar as we need to, for our alternative case, on the public policy exception to the Foreign Act of State doctrine. The judge dealt with this fairly briefly, must be said, at paragraph 101 of his judgment. He says here, having referred to Williams and Humbert, the principle that foreign legislation is generally recognised and not questioned, he said this: there may be circumstances in which the English court would take a different view, for example, Oppenheimer and Cattermole, but these cases are probably explicable, as to which see a passage in Professor Briggs' writing, on the basis that the foreign law is so disgraceful as not to be regarded as law at all. This case, Cattermole, was referred to by Mr. Atkins as an example of what he called English private international law's armoury of principles, to allow an English court to disregard objectionable foreign law, even if that law and things done under it remain valid in the foreign jurisdiction. But I agree with Mr. Crow's submission that there is nothing remotely like that in the present case. Oppenheimer was concerned with Nazi race discrimination laws depriving Jews of their nationality. The offending act in the present case is a deprivation of director control, not a shareholding expropriation, and the law provides for claims to compensation in the event of trustee misappropriation. With respect to the judge, the reasoning here is unsustainable for 3 reasons. First, the court has my submission that the Foreign Act of State doctrine has no application to foreign judgments. And it follows that there is no need for us to invoke an exception to that doctrine, however broad or narrow it may be, in order to challenge the Sur judgment. Our challenge to the Sur judgment depends on well-established common law rules attacking foreign judgments as being corrupt, contrary to substantial justice, and so on. The judge rightly recognised that we have a triable case, that the Sur judgment is in fact corrupt and unjust. So that's the first point. The second point is that if and insofar as we do need to go further than the Sur judgment and challenge the Turkish legislative and executive acts themselves, and thereby do engage the Foreign Act of State doctrine, we say the judge's reasoning at paragraph 101 does not recognise the true scope of the exception to the Foreign Act of State doctrine for public policy. Now, in fairness to the judge, I don't think he was referred in oral submissions to the UCOS case, which was the UCOS case, which identified that public policy exception. And critically, he didn't have the benefit of the Supreme Court's guidance in Venezuela on it. But what those authorities make clear is that the public policy exception applies where the relevant Foreign Act of State either breaches clearly established rules of international law or contravenes English public policy principles or gravely interferes with human rights. Now, Oppenheimer, of course, was a crystal clear case falling within the public policy exception, and I don't suggest that our case is on all fours with Oppenheimer. The point is that Oppenheimer does not exhaust the scope of the exception. It illustrates it. And the judge misunderstood that. His reasoning here was premised on the error that in order to invoke this exception, we had to show that our case is an Oppenheimer and Catamore case, and we don't. We just have to show...
You do have to show it's pretty grey.
Indeed. And I don't shrink from that, and the allegations we make are grave allegations. We allege a politically motivated campaign to oppress Mr. Ipek, which involves breaches of human rights. And I don't know if the court has had the opportunity to read our re-amended particulars of claim. The re-amended particulars of claim are in tab 14 of the core bundle.
And how does the recent decision of the European Court of Human Rights fit with this argument?
I'm going to come on to that, my lady. Let me summarise what we say in relation to it. The first is it's a decision of the committee, and it may not be the final word at the European level because we have applied to have the case reconsidered by the full chamber. That's the first point. The second point is it's not binding. It was a decision as between Turkey and Mr. Ipek, so it can't give rise to any res judicata effect in this jurisdiction. So far as it deals with factual matters, it isn't the function of the European Court to find facts. It's the function of the national court, in this instance the English court, to do so. And insofar as the decision does purport to make factual findings, they would be inadmissible in this court under the rule in Hollington and Hughes. And the fourth point we make is that the reasoning of the European Commission is all premised on a factual case that bears no resemblance to what our case on the facts is in this litigation. So to give a single example, the European Court proceeds on the basis that Judge Sur is independent and impartial. But everyone in this litigation accepts that we have a tribal case that he's not. He made a corrupt judgment. And I'll come on to this when we go through the reasoning of the European Court. But at every stage along the way, it just doesn't fit with the facts as we allege them to be. And so what we say is the European Court decision just illustrates the serious issues that there are to be tried in this case. It will of course be necessary for the trial judge, when he or she comes on to consider our allegations, having found the facts, to apply ECHR case law to it. The trial judge will be bound to have regard to that case law, and insofar as the Commission decision in this case remains the final word, he or she will have to take account of that for what it decides.
And the human rights that you say that have been gravely infringed are A1P1 and Article 6.
Indeed. And if I can just give the court the references to the pleaded case on that. It's in tab 14 of the core bundle. Paragraph 99 through to paragraph 104.
Page
185 through to 187.
185.
Sorry, through to 188.
Do you want us to read that?
Insofar as it matters to the court's analysis, because by this stage I'm on my alternative case. But if the court takes the view that that's the only way I can get home, and I need to show...
It may matter, because the case put against you is that the SIR judgment is just effectively part of the background. It's not actually the basis for the appointment of these directors as opposed to the previous ones.
Indeed.
So I think we probably do need to see how that's put.
Indeed. And I would invite the court to read what is alleged at 99 and following in relation to the Turkish Executive and Legislative Acts in the light of what we plead in section D of the particulars as to the relevant background in Turkey, which includes our allegation that the rule of law has generally broken down there, and in the light of sections E and F dealing with the SIR judgment. And also to have the court keep in mind that it is conceded that we have a triable case that the SIR judgment is corrupt. And so the question when we get to the alternative case is, are there serious issues to be tried in a world in which the SIR judgment is corrupt, that the Turkish legislative and executive acts made on the basis of it can be attacked on public policy grounds? And we say the answer is plainly yes, we do have serious issues to be tried on all of these points. And returning to what we say on ground 4, I've given the court the 2 reasons so far for attacking the judge's reasoning. The third is the one we have just been discussing, that it was just not appropriate for the court to attempt to resolve on a summary basis whether or not our case to invoke the exception to the Foreign Act of State doctrine is right or not. It is a classic example of an issue for the trial judge, having found the relevant facts. And if I can just give 2 examples of this. One of the reasons the judge gave as to why we couldn't come in the scope of this exception, as he identified it, was that the acts in this case don't involve deprivation, they involve the imposition of control. But we don't accept that on the facts. The measures in this case, imposed by Judge Suhr and in place ever since, have been in place for 7 years. They were purportedly put in place under Article 133 of the Turkish Criminal Code of Procedure for the purpose of an investigation into criminal offences. What they have morphed into, we say unlawfully, is a regime to protect against commission of offences in the future. We also say on the facts that when the true scope of the trustee's powers are understood, they are not simply powers of directorial control. Trustees also have the power to act as shareholders. The court's note, that's Dr. Osby's expert report below, paragraphs 100 to 113 in the supplemental bundle, page 207 to 210. And to give the court another example.
Sorry, so you say it's not just about control because they have the ability to act as shareholders. Is that not still about control?
It's 2 points. It's not about temporary control, because assessed as a matter of substance, this regime is not temporary. And it's not just about directorial control, because the trustees have the powers to act as shareholder as well.
But the contrast was being made with deprivation of property, and there hasn't been yet, at any rate, any deprivation of property.
Our case is that in substance there has.
Because the control has lasted so long.
Because the control has lasted so long, and it is not simply directorial control, it is also shareholder control as well.
As to that latter point, I'm not sure I get grasp why that makes a difference, really. I mean, there are two ways in which you can control a company, through the board or through shareholder rights. But if you're not taking money out of the company or whatever, is it still not about control?
Oh, my lord, our case will be that it isn't, because if you look at this from the perspective of Mr. Ipek and his family, who are formally the shareholders in this company, they find themselves in a situation where they have no control of the appointment of directors and they have no ability to exercise their shareholder rights. It is difficult to see what is left of their property in the company. And all the judge appeared to have suggested was left was the right to seek compensation for trustee mismanagement. That is one of the points which he identifies as a reason why we couldn't rely on the exception. But one needs to assess the possibility, in reality, of obtaining that compensation, where our case, which is triable, no one disputes that, is that the rule of law has broken down in Turkey and its courts corruptly act in the service of the regime there to further a campaign of oppression against Mr. Ipek, his family and his assets. If we are right on those factual allegations, there is no remedy for us in the Turkish courts. And on all of these points, it is with respect unrealistic to think that they could be summarily determined. They are all matters for trial. My lord, that's all I propose to say at this stage on the grounds of appeal. I turn next to the respondent's notice point. And there are 5 additional grounds, but they break down into 2 categories. And the 2 categories are quite different. The first category is additional grounds 1, 1A and 2. And these seek to defend the trustee's authority by reference to developments after the sewer judgment. We've got 3 developments they rely on: the Turkish Constitutional Court decision, the decision of the Committee of the European Court on Human Rights, which I've already touched on, and the transfer of appointing powers to the SDIF. Now, we say that none of those developments cures the corrupt sewer judgment, and each of them bristles with serious issues to be tried. So that's the first category, and I'll develop our case by reference to each of those 3 developments in a moment. There is then a second category of respondent's notice point. These are grounds 3 and 4. Now, these points are very different because they don't engage with the merits at all. They are pure points of English procedure. Ground 3 is whether the gateway applies, and ground 4 is whether it was an abusive process for us to seek permission to serve out of the jurisdiction at this stage of the dispute. The case on the other side is that we should have sought that permission right at the start of the case, even though the court had concluded that the Brussels regulation applied, with the consequence that it couldn't have granted the permission in any event.
Well, you got pretty short shrift from any judge who was engaged in proper case management.
Indeed, I mean, you also have to imagine the
spent
scene.
2 days dealing with the alternative case.
We pitch up in front of Mrs. Justice Asplin, who's dealt with a point under the Brussels regulation. And we say, now we want you to deal with another issue. You can't give us this permission, but we want to debate in front of you all the issues which we debated over 2 days in front of Mr. Justice Trower. The judge gave each of those pure procedural points short shrift. They're dealt with in my written argument. I'll obviously hear what Mr. Crowe has to say,
Yeah.
but I wasn't proposing to develop them all.
Well, we hear what Mr. Crowe says about this.
What I will just say finally, by way of entree on those 2 procedural points, is that ultimately they are entirely arid, even if they had any substance. Because ultimately, if these trustees want to pursue their attempts to take control of Koza Ltd, they will at some point need to invoke the English court's jurisdiction. And they will then need to persuade the English court that they have authority to represent Koza Altin as shareholder of Koza Ltd. So, like the run-up to the Supreme Court we had, which took 3 years at considerable expense, these are just arid points. They attack the procedural vehicle for raising the authority issue. They don't bear on the substance at all. So that's all I wanted to say about the 2 procedural grounds. Let me turn to the substantive grounds, if I can call them that. The first of those relates to the Turkish Constitutional Court decision. And just so your lordships and your ladyship have the context for how this issue was dealt with below, can we go back to the judgment behind tab 10? So I'm so sorry, tab 11 in the call bundle. Your lordships and your ladyship could turn to paragraph 82 in the judgment. Page 120 in the bundle.
Yeah.
Judge says, although Mr. Jonathan Crowe QC, who appeared for Koza Altin and the individual defendants, said that the allegations in relation to deficiencies in the functioning of organs of the Turkish state were hotly contested and would be difficult to establish given the large number of individuals and entities now involved, he accepted that many of them could not be resolved on an interlocutory basis. His oral submissions did not therefore concentrate on the question of whether or not there is serious issue as to the integrity of the SOR judgment, and then this, as reviewed by the Sahin Bey judgment and on appeal by the Turkish Constitutional Court. So the argument now being put to this court that the Turkish Constitutional Court judgment is a knockout blow, a killer point that means we can't go to trial, wasn't even run below. And not only that, it wasn't foreshadowed in the evidence which the trustees served, which very, very helpfully and very properly identified the arguments that they advance as a basis for summary determination. And the court will see those arguments as then set out in the skeleton, identified at 89 in the judge's judgment. Nowhere in any of that was it suggested that the Turkish Constitutional Court decision was a basis for summary judgment. And the consequence of that is that this issue just hasn't been properly ventilated in the evidence, it wasn't ventilated in argument below, and it emerges before this court for the first time in what is a fairly congested hearing. So that is the context of the Turkish Constitutional Court point. The point is put as involving 2 propositions, and the court sees these at paragraphs 37A and B of my friend's skeleton at tab 10. And the court turned that up. It's at page 89. the point at subparagraph A appears to be advanced as a proposition of law that where an impugned foreign judgment has been upheld on appeal, it is necessary to establish deliberate misconduct as opposed to error on the part of the relevant appellate court as well. So that's the first point, and that proposition of law is advanced on the basis of two first instance decisions. Maximov, the decision of Sir Michael Burton following a trial, and Rogostrak, a decision of Mrs. Justice Mulder determining that there were serious issues for trial. Our short answer to the proposition as put as a point of law is that it is wrong. What has to be shown in order to establish a ground for non-recognition depends on all of the circumstances of the case. Two particular circumstances are relevant in relation to Maximov. The first is that it was in dispute in trial at that case as to whether any of the three Russian judgments, the first instance and then the two appeal judgments, was corrupt.
So
It was disputed whether any of those judgments was corrupt. And the conclusion which Sir Michael Burton reached following the trial is that none of those judgments was corrupt. Contrast the present case, where my learned friends concede, for present purposes, that the Sewer judgment is corrupt and that its corruption was not cured on the horizontal appeal to Peace Court Judge Sahin Bey. So that's the first distinction. The second distinction is that Maximov and Rogostrak were both cases involving conventional appellate processes. So cases in which the appeal courts addressed whether or not the decision on the merits was right or wrong. So to take Rogostrak as an example, that was a reinsurance dispute. The issue was whether the insurance covered a flight. That issue was considered at every stage in the Russian appellate system. It was considered at first instance and then twice on appeal. And the same is true in Maximov. Contrast that with the present case. As a matter of Turkish law, there is a conventional appeals process, but it has no application in relation to peace court judge hearings. For peace court judge hearings, there is a special procedure whereby you have the right to have your case reviewed by another peace court judge, which is how we ended up in front of Peace Court Judge Sahin Bey. But our case, conceded to be triable, is that each stage of that process was corrupt. The Turkish Constitutional Court sits outside the conventional appellate structure. It is a court whose job and whose jurisdiction is limited to the consideration of constitutional points. So what the Turkish Constitutional Court did not do was consider on the merits whether the appointment of trustees was right or not right. And the consequence of that limit on the Turkish Constitutional Court's jurisdiction and function is that as matters stand, there has been no non-corrupt judicial investigation in Turkey as to whether these trustees should be in place. So that's the first point. That deals with the point as put as a proposition of law. And if we are right as regards the Turkish law points concerning the limited jurisdiction of the Turkish Constitutional Court, there will be no need for us to impugn its decision-making. And it will be an issue for trial whether or not we are right as a matter of Turkish law That is the nature of its jurisdiction.
Just to be clear about that, they do have jurisdiction to consider human rights issues.
Yes.
Are not your complaints largely human rights issues?
Some of our complaints are. But the complaint about corruption by Judge Sewer is not necessarily a human rights complaint. And what I don't know, I'm afraid, my lord, because it hasn't been explored in evidence, is how far the Turkish Constitutional Court's jurisdiction to investigate human rights issues would also encompass a jurisdiction to make factual findings about allegations of corruption. One can speculate, of course, that it would be very surprising if a constitutional court had the jurisdiction to make those sorts of factual findings. Certainly the Supreme Court would not entertain them in our jurisdiction, and neither would this court. It would remit the matter to a trial judge to consider the allegations if it considered them relevant to the issue in the case. But that will need to be investigated in the Turkish law evidence in due course.
And possibly anticipating what you're going to say, you made the point a moment ago, well, this wasn't really something that was live below. What impact do you say that has? Or to put it another way, do you say, well, this is just not something that Mr. Crowe can be allowed to run in this court, or is it rather something that has to be taken into account in evaluating his submission?
It's a take into account point rather than a hard-edged, he's not allowed to run it. And the way I put it is to say there is really nothing in this Turkish Constitutional Court point. For the first reason I've been addressing you on about Maximov and Rogostrach and the limited scope of the Turkish court's jurisdiction, but also for the second reason that I'm about to come on to, that we in any event have a serious case for trial if we need it, that the Turkish Constitutional Court decision can be impugned as well. What I say is, if your lordships and your ladyship, having heard the arguments, are in any doubt as to whether this part of our case raises serious issues to be tried, the fair thing to do is to remit it to the trial court for determination with all the other serious issues to be tried. What would be unfair, given how the point has arisen, is for it to be summarily determined against me for the first time in this court. I hope that answers your lordship's question as to how hard-edged a point we make it. So I've addressed the court on the Maximov-Rogostrach point. Can I turn next to our argument, if we need it, that there are serious issues to be tried as to whether the Turkish Constitutional Court decision can be impugned. And we invite the court to keep in mind the context in which that question arises. It is accepted that there are serious issues to be tried on our factual case on 4 propositions. First, that the rule of law and protection of human rights has generally broken down in Turkey. Second, that Mr. Ipek, his family, and the Koza Ipek group has been the target of a politically motivated campaign of oppression by the Turkish state. And third, that in furtherance of that campaign, a peace criminal court issued the corrupt Sewer judgment. And fourth, that the corrupt Sewer judgment was not cured by the horizontal appeal to Peace Court Judge Sahin Bey. And that is the context in which my learned friends must persuade you that there is no serious issue to be tried as to the propriety of the Turkish Constitutional Court's decision. And in my submission, that is not realistic. Again, it is a matter for trial. And what I want to do here is first to summarise for the court some of the evidence that we rely on in relation to the context in which the Turkish Constitutional Court's judgment was given. And then I want to identify to your lordships and your ladyships some of the features of the Turkish Constitutional Court's judgment on the basis of which we will say, if we need to, that it too can be impugned. In the lower court, we served an independent expert report from Professor Sir Jowl, QC. It's in the supplemental bundle, tab 13, beginning at page 90. It is fair to say it is a very long report, and what we have done is to prepare a summary table for the court, identifying the key passages. I've provided this to my friends on Monday. I don't understand there to be any objection in my handing it up. Right. Thank you very much. What this is intended to do is to identify passages in the Jowl report that go to these contextual issues that apply to the Turkish Constitutional Court judgment. And we say the Jowl report supports the following propositions, as to each of which there is a serious issue to be tried. The first is that the rule of law in general and independence of the judiciary in particular has been in steady decline in Turkey since 2014, and executive interference picked up in particular following a coup d'etat in 2016. The result is that executive interference was particularly heightened at the time the Turkish Constitutional Court judgment was delivered in May 2018. The second point is that executive interference with the judiciary is of a special concern in cases involving alleged Gülenists, whom the Turkish government regards as enemies of the state, with such executive influence being one aspect of that government's campaign to purge the alleged Gülenists. Of course, Mr. Ipek is falsely accused by the Turkish state of being such an individual. That is the whole premise upon which the trusteeship is built. The third proposition supported by the Jowl report is that a particular feature of the Turkish government's purge has been the confiscation of assets and the closing down of media outlets. Both of that has happened in the case of the Koza Ipek group. Fourth proposition is that executive influence on the judiciary in Turkey is exercised both directly, for example, by the Turkish government detaining or removing judges from office, or it is exercised indirectly by the ongoing threat of consequences for judges who are perceived to be Gülenist sympathisers or otherwise acting against state interests. One of the striking statistics identified in the Jowl report is that there has been a wide-ranging purge of the judiciary in Turkey, including dismissal of nearly 1 in 3 Turkish judges and imprisonment of many of those detained, in some cases in solitary confinement. There are specific examples of Turkish Constitutional Court judges being dismissed and detained, and of such detention being found unlawful in the European Court of Human Rights. The fifth proposition is that there is a political climate in Turkey in which judicial independence could be expected to be compromised in political cases, i.e. those in which the state has an interest. Just to give the court a single vivid example of the Turkish executive's approach here, take the statement of its Minister of Economy in August 2016 in relation to the arrested judges and prosecutors. That minister said, "These betrayers will be punished the way people wanted. We will make them beg, we will stuff them into holes, they will suffer such punishment in those holes that they will never see God's sun as long as they breathe. They will not hear a human voice again. Kill us, they will beg." It's in the supplemental bundle, tab 13, page 137. And the court may have seen from our skeleton that Judge Suhr himself has made similar such statements on his Twitter account. Sixth proposition supported by the JAL report is that the Commissioner for Human Rights for the Council of Europe has doubted the effectiveness of the remedy that the Turkish Constitutional Court provides, in particular in politically sensitive cases. Other internationally renowned reports also raise specific concerns about the impartiality of the commercial court, as identified by Professor Jal. Seventh, there are specific examples of the Turkish Constitutional Court abdicating its responsibility in politically sensitive cases. For example, it has found that it did not have the jurisdiction to review the various emergency decrees made following the attempted coup d'etat. And it found the detention of one of its own to be lawful, a conclusion with which the European Court of Human Rights disagreed. Eighth, a state of emergency inquiry commission has been established in Turkey, but it is not independent of the executive. It is very slow to make decisions, and it has effectively been designed as a reason to allow the Constitutional Court to dismiss applications on the basis that remedies should be sought before the Commission. And that is one of the things that the Constitutional Court said in the case of Mr. Ipek's application. Now, the present case is precisely the kind of political sensitive case in which we would expect the Turkish judiciary to have been the subject of and to have submitted to executive influence. We make that point with references to the evidence of paragraph 24 of our supplemental skeleton. That's tab 18, page 231 in the core bundle. So, two contextual aspects here. First, the concessions about the allegations in our case. And secondly, the evidence in the JAL report as to the situation in Turkey generally. And against that background, I come to the Turkish Constitutional Court judgment. Now, we say there are various aspects of this judgment which, in the context that I have described to the court, show that there are serious issues to be tried as to its propriety. And we identified those features in our supplemental skeleton at paragraph 25, tab 18 in the core bundle, page 232 and 3. And to give the court just two examples. First, one of the complaints before the Turkish Constitutional Court is that peace court judges are not independent or impartial. The Constitutional Court dismissed that complaint as, in its words, clearly without ground. That's paragraphs 113 and 4 of its judgment, supplemental bundle, tab 40, page 443. That finding is impossible to reconcile, we say, with the various sources of contrary evidence about peace court judges in Professor Jal's report. And it is difficult to reconcile with the trustees' own stance in these proceedings, in which they accept that there are serious issues to be tried as to whether the Suhr judgment is correct. Second, the Constitutional Court concluded that the horizontal appeal to another peace court judge was sufficient to meet any injustice, on the basis that in Mr. Ipek's case, he could have challenged on the horizontal appeal the so-called expert report, the Kamatli report, prepared by a member of the Erdogan government, an individual associated with the Erdogan government, that had been relied on by Judge Suhr. That's paragraphs 111 and 2 of the Constitutional Court judgment, supplemental bundle, tab 40, page 441 and 2. Now, that position about the possibility of challenge in the horizontal appeal is again contrary to the evidence of Professor Jal. It is also contrary to the trustees' own stance because they accept that there are serious issues to be tried as to the deficiencies with the horizontal appeal to Judge Sahib. And placed in the context of the wider deficiencies, as alleged in our pleaded case and as set out in the JAL report as to the state of the rule of law in Turkey, we say that these criticisms and the others set out in our skeleton argument amply demonstrate that there are serious issues to be tried as to whether the Turkish Constitutional Court judgment cured the corrupt sewer judgment. And ultimately, that's all I propose to say on the Constitutional Court judgment. We come next to the Committee of the European Court of Human Rights decision. The trustees here advance two arguments in relation to the committee's decision. First, as with the Turkish Constitutional Court, they say that we must show as a matter of law deliberate misconduct on the part of the committee. That's their skeleton, paragraph 37C, tab 10 of the core bundle, page 19. And that's wrong for the same reasons that I've submitted to the court in relation to the point taken in relation to the Turkish Constitutional Court and the misplaced reliance on Maximov and Bogostrad. So that's the first point. It also bears emphasis here that the European Court of Human Rights, of course, is not a part of the Turkish legal system, and it does not offer an appeal from the SUR judgment, and nor does it have the power to set the SUR judgment aside. The second point the trustees make is to say that it would now be hopeless for us to seek to impeach the SUR judgment, given that the application to the European Court failed. That's 37D in their skeleton, tab 10, page 19. We respectfully disagree for three reasons. The first is that the committee's decision does not resolve any of the serious issues for trial that arise on our case. Mr. Ipek brought that application against Turkey, alleging that the Turkish processes infringed the presumption of innocence, infringed his right to property, and his freedom of expression contrary to rights protected under the ECHR. The application was obviously not concerned with the question of English public policy and the recognition of judgments under English private international law. In particular, the European Court was not asked to find that the SUR judgment was corrupt. It is not the function, of course, of the European Court to make such a finding. The decision on the application does not create any res judicata, quite apart from the fact that it did not consider the same issues as arise in these proceedings. Koza Ltd was not a party, Koza Altin was not a party, and the trustees were not a party. So there can be no suggestion that the committee decision creates any estoppel that precludes our case in these proceedings. So far as concerns the statements of fact in the committee's decision, even if one were to treat those as findings rather than assumptions made by the court as to the facts, those findings would not be admissible as evidence in these proceedings, the English proceedings, under the rule in Hollington and Heath. In the ordinary way, it will be for the English court to make its own findings on the admissible evidence before it. The second point we make is that the committee's decision also does not shed any real light on the serious issues for trial in this case about the propriety of the SUR judgment. If we can turn it up, it's in the Laddam Marshall bundle, which I think is the slimmest of the various bundles the court has. And it's behind tab 4. Now, the committee dismissed Mr. Ipek's complaint in relation to the presumption of innocence because it found that the Turkish authorities did not hold him out as guilty of offences, but merely the subject of investigations against him, and that was held to be permissible under Article 6. The court has that conclusion at paragraph 78 of the judgment. Now, whether or not that non-binding and inadmissible finding
You
is
mean
correct-
78?
I'm so sorry, I mean 72, thank you.
Sorry, give us again.
72,
Paragraph 72.
paragraph 72. Now, a short point here is that this has nothing to do with the issues before the English court about corruption on the sewer judgment. So far as concerns the next complaint, interference with Mr. Ipek's property, his case to the European Court was that the Turkish measures appointing trustees infringed Articles 6 and 7 ECHR and Article 1 of the first protocol. But the committee decided to assess the case only under Article 1 of the first protocol. You see that at 78 and 79. In the result, it did not consider whether the processes before Judge Sur, Judge Sahibe, and the Turkish Constitutional Court complied with Article 6. Still less did it consider whether they were corrupt for common law purposes. What the committee did was to treat the Turkish measures generally as, in the words of the committee, preventative measures which temporarily restrict the use of property by its owner. And they examined the case from the perspective of, again, in the words of the judgment, the right of the state to regulate the use of property in accordance with the public interest. That's paragraph 81. Now, pausing there, our factual case in these proceedings is that the sewer judgment is not a temporary measure of control, it's a permanent interference. Now, insofar as the committee assumed otherwise, or found otherwise, it was, with respect, wrong. It is also our case in these proceedings that the Turkish measures were done in furtherance of a politically motivated campaign of oppression. And the committee's decision sheds no light on that. Insofar as it found or assumed that it can be in the public interest for a state to pursue such a campaign under Article 1 of the first protocol, that was, with respect, wrong. Paragraph 82 of its judgment, the committee finds that Article 133 of the Turkish Code of Criminal Procedure pursues a legitimate aim, which is to prevent the commission of new offences. Now, our case in the present proceedings is that the true aim pursued by Article 133, as is apparent from its express terms, is to permit investigation of existing offences. And the committee offered no reasoning for finding that Article 133 has a wider preventative purpose, and with respect, it was again wrong. The committee found at 83 to 86 that the Turkish measures were proportionate for three main reasons. Each of them would be unsustainable in the context of our factual case in the present proceedings. So first, the European Court finds that the measures were ordered by an independent judicial authority. That's Judge Sur, who the trustees concede to be arguably corrupt, and who the judge below found to be so for the purposes of serious issue to be tried. Second, the court refers to Judge Sur's reliance on an expert report. That's the Komatli report, a report prepared on our case by an associate of the Erdogan regime, rather than an individual on the court-approved list of experts, and which we give the Komatli report as a particular of the very corruption which the trustees concede to be argued. The third strand of reasoning on proportionality was the court's reference to the fact that appeals had been brought in Turkey. court has my submissions that those appeals were corrupt or irrelevant, and either way didn't cure the sewer judgment. The committee also found, this is 93 to 94, that the Turkish measures were, in their words, surrounded by a number of other guarantees, referring to the possibility of challenging the measures in the Turkish courts and obtaining compensation there. The court has my submission that our case in the present proceedings is that Mr. Ipek cannot get substantial justice in Turkey. So there would be no point in him seeking compensation there. To do so would just generate another unjust judgment. So when the court stands back from the detail of the European Court's reasoning, what the court will see is that the committee rejected the complaint under A1P1 on the basis of facts which bear no resemblance to our factual case in the present proceedings. And that illustrates that what needs to happen is for the facts to be tried, and once they have been found, for the law to be applied to it. And if the facts are found in the same way as the European Court assumed them to be, then it may well be that the European Court's analysis of the ECHR rights in question will be correct. But if the facts are as we say on our case, it's impossible with respect to see how the European Convention on Human Rights would permit the sorts of things that we allege to have happened in Turkey.
But if you're right on, as it were, the primary point, in the sense that this court were to decide that you should have permission to serve out and the case should effectively go to trial, then the trial judge is going to have to decide on the evidence before the trial judge, not on the material that's in this. It's no answer to say, well, it's all been decided by the European Court.
Indeed.
For the reasons you give. One, it's not res judicata, and two, it's at least arguably not admissible in any event.
Indeed.
Just before you move on, can I ask one thing? You point out that the committee says it's going to examine this by reference to A1P1, having mentioned that Article 6 had been invoked as well. What would separate reference to Article 6 have raised that the committee did not consider?
It would have raised consideration of the specific complaints that we made in relation to Judge Suhr. But what appears to have happened is that the committee assumed, on the basis of what the Turkish Constitutional Court had said, that the processes in Turkey were impartial and independent. And of course, it's that factual issue that we join issue with. So as a matter of legal analysis, it may well have made no difference. But on the facts, it makes all the difference. Because once the facts are, as we allege them to be, that the Turkish judges were corrupt, it's impossible to see how Article 6 could be complied with. And it's impossible to see how A1P1 could be complied with. But it all, in a sense, ultimately goes back to my Lord the Chancellor's point. The facts have to be found, and once they've been found, you can apply the legal principles to them. But at this stage, all the court has to go off are our allegations and the evidence we've adduced in support of them, where they have been joined issue with by the trustees. And the picture that the court is left with is a picture of a case, I submit, which bristles with serious issues to be tried. And none of those issues is resolved by this decision from Europe. Well, the final point we make here is we invite to keep in mind that the committee's decision may not even be the end of the matter at the European level. Mr. Ipek has applied to the European Court for the issue to be reconsidered by a full chamber rather than the three-member committee. His application has yet to be ruled on. And so even if, contrary to all my other submissions, the court thought that this committee's decision was somehow a killer point that would prevent this case going to trial, it would, we say, be unfair and premature to dismiss the proceedings while Mr. Ipek's application before the European Court remains outstanding. The appropriate thing to do is again to remit the case trial at first instance, and the decisions in Europe will just form part of the issues for the trial judge to grapple with. So that's the European Court point. We come then finally to additional ground 2, which is the trustee's argument that their authority does not depend on the Sur judgment, but rather it depends on what they describe in their skeleton as legislatively sanctioned administrative decision-making of the SDIF. And they say that decision-making cannot be challenged here, given the Foreign Active State doctrine. And we say that additional ground is unsustainable for 2 reasons. First, all the Turkish legislative and administrative decisions provide for is the transfer to the SDIF, or to persons appointed by it, of powers that derive from, and only derive from, the Sur judgment. And that is the point that Mr. Atkins made to the judge below when he said the root of all of this is the Sur judgment. And one sees that root in 2 respects. Firstly, the relevant Turkish decrees and legislation don't apply specifically to Koza Altin. They apply to all companies which have had trustees appointed to them under Article 133 on the basis of an association with terrorist organisations. Koza Altin is only such a company on the basis of the Sur judgment. So this legislation only applies on the basis of the Sur judgment. That's the first point. And the second point is that what the decrees and legislation expressly provide for is the transfer of power, not a fresh source of power. And so our primary argument is that there is no need for us to attack Turkish decrees, Turkish law, and the administrative decisions taken by the SDIF, because they are all built on the Sur judgment. And if this court accepts our case that the Sur judgment is corrupt and cannot be recognised, there is no space left to recognise the Turkish law and administrative acts that are built upon it. So that's the primary argument. That argument ultimately will turn on examination under Turkish law as to how the Sur judgment fits in with the legislation and the decrees. Now, I'll come on to this at the end of my submissions. That was addressed to some extent in the evidence. But it's going to be among the matters that are for trial if the trustees dispute that the Sur judgment provides the basis for the legislative and administrative regime. Because if they do dispute that, we do not accept that. And that is a matter that will need to go to trial. So that's the first point. The second point I've already addressed the court on. That's our argument that if we do need to challenge the Turkish legislative and executive measures, we can do, because the public policy exception to the Foreign Active State doctrine will apply on the basis of the allegations we make, and the court cannot properly determine on a summary basis whether or not our case on that exception is correct. That is again a trial. Can I just round off this point by just showing the court how this point was dealt with below?
Just to be clear, this is another take into account point, not
Indeed.
entertain point.
This is an entertain, but do so in a way that is fair. Now, what happened below is that we adduced independent expert evidence from Dr. Osby, who is a former judge of the Turkish Court of Cassation, regarding the steps that were taken in Turkey after the Sur judgment. And the relevant passages are paragraphs 17 to 22 in his report, tab 14 of the supplemental bundle, page 189 to 190. And his conclusion was this. He said, those who manage and control Koza Altin ultimately derive their power from the sewer judgment, and the power of the present appointees, it's the trustees, therefore rests on the validity of the appointment of the trustees by the sewer judgment in the first place. Now the trustees adduced their own independent Turkish law evidence from a Dr. Dulga, but he did not dispute this point. And it was against that background that we submitted in our skeleton to the judge as follows. We said the power of the current trustees is dependent on the sewer judgment, which appointed the trustees in the first place. That is not disputed by Dr. Dulga. That's paragraph 26 of our skeleton below. Tab 22 in the supplemental bundle, page 327. The trustees' skeleton did not demur on that point. On the contrary, they stated that the Turkish measures provided for, and I quote now, the authority of trustees to be transferred to the Savings Deposit Insurance Fund of Turkey. That's paragraph 20 of the trustees' skeleton below, supplemental bundle, tab 23, page 346. So they appear to agree with our point on this being a transfer of power rather than a fresh grant of power. At the hearing, and one sees this from the transcript, my learned friend Mr. Crowe took the judge through the Turkish sources, but he did not suggest, so far as I can see from the transcript, that any of the Turkish measures after the sewer judgment constituted an independent source of authority. That's pages 175 to 181 of the transcript, supplemental bundle 44, 503 to 504. And my client's leading counsel at that hearing, Mr. Atkins QC, he was not contradicted when he told the judge in his reply submissions that, and I quote, it is common ground that the root of the director's authority is the sewer judgment. That's page 275 of the transcript, lines 17 and 18, supplemental bundle 45, page 582. So again,
Sorry, page 58.
58. Sorry, 528. So again, new point raised for the first time on appeal. We have not had fair opportunity to address it in the evidence or in argument at first instance. If your lordship are in any doubt, the lordship is in any doubt as to whether there are serious issues to be tried here, the fair course and the appropriate course is to remit it for trial along with the rest of the
It can't be decided on a summary basis. There's no evidence to support the assertion that the power is anything other than derivative.
Indeed.
I mean, you pointed us to Dr. Altin's report, which I think we probably all read, and that's not disputed by Professor Dolga.
Otherwise, my lord, that's all I had to say, unless there's anything further I can assist you with.
No, thank you very much, Master. Scott. Yes.
We were going to address you under three broad headings. The question whether there is a serious issue to be tried, which is by far the largest and embraces almost everything in one way or another. Secondly, the question of whether or not there is a gateway for service out. And thirdly, whether the approach that the appellants have taken in this case constitutes an abuse of process. On the first of those then, obviously the main issue is whether Mr. Justice Trower was correct in the way he dealt with the question whether the authority claim raises a serious issue to be tried. And to put it very shortly, our response to the appeal is that he was right for the reasons he gave. The core passages that you will already be familiar with are in paragraphs 91 to 103 of his judgment. Now, the first point that my learned friend seeks to make is to say that Mr. Justice Trower accepted our argument essentially because, so my learned friend says, the judge below agreed that the identity of the directors of Koza Altin is a matter of Turkish law. There's no dispute about who the directors are under Turkish law, and therefore, on my learned friend's analysis of Mr. Justice Trower's argument, judgment, the authority claim fails. And my learned friend calls that the choice of law issue. We don't really understand why that can be sensibly described as a choice of law, but I won't quibble about nomenclature. What my learned friend says as a matter of substance, he says that assuming that that was Mr. Justice Trower's approach, it was erroneous because, my learned friend says, in every case in which an issue of recognition of a foreign judgment arises in this court, by definition, the foreign judgment is valid in the foreign jurisdiction. So he says that the point upon which Mr. Justice Trower latched should be regarded as the starting point for any question of recognition, not the answer to any question of recognition. Our principal response to that is to say that, with the greatest respect, my learned friend has mischaracterized or misunderstood what Mr. Justice Trower was doing. And the whole argument you have been listening to on the main point begs the key question as to whether, in this case, the English court is being asked to recognize anything that has happened in Turkey at all. If we can approach the main issue in this way, if a defendant is sued by a corporate claimant, that defendant is in principle entitled to challenge the authority of those individuals who purport to give instructions for the proceedings to be issued in the name of the company claimant. Similarly, if a claimant sues a corporate defendant, he is, in principle, entitled to challenge the authority of those individuals who purport to give instructions for the proceedings to be defended in the name of the company. All of that perfectly trite. And that was the line of authority that my learned friend mentions in his skeleton as referred to in paragraph 92 of the judgment below. If we just briefly look at that. So core bundle tab 11. Page 122. So what the judge below says is, where a defendant is faced with proceedings brought in the name of a claimant without authority, he may have an interest in having the question resolved, which can be vindicated by applying to have the proceedings struck out as abuse, and he cites John Shaw, Airways Limited and Bowen, and Zoya and Ahmed. I think it's arguable that a company faced with a shareholder seeking to exercise shareholder rights enforceable by action in England is in a similar position that has and has a legitimate interest sufficient to challenge the authority of those procuring the shareholder to exercise those rights. it should not matter whether the issue arises in the context of proceedings in which the shareholder is claimant or defendant, and reference is made to Young and Toynbee. That is the case, even though the underlying dispute may be one between two warring shareholders, such that it would be wrong for the company itself to bear the costs of determining the issue. Now, those various cases, John Shaw, Airways Limited and Bowen, and Zoya and Ahmed, are not in the authorities bundle because the principle that they illustrate is well known. But it may be just worth noting what they actually involved. So John Shaw was a case in which there was a question whether the directors who had caused the proceedings to be issued, in fact, had lawful authority under the constitution of the company to do so, because there had been a division of power between different categories of director. Similarly, Airways Limited and Bowen, a question was raised as to whether the person who had purportedly issued instructions for the proceedings to be issued was a director at all, and that was the matter that came in front of the court. And similarly, the third case, Zoya Limited and Ahmed. Again, the question was whether the person who gave the solicitor's instructions to issue proceedings had in fact been appointed as a director. Now, those are all cases in which it can clearly be seen that what the other litigant is doing is challenging the authority of the individuals who purport to give instructions to issue or defend proceedings in the name of a company. But that is simply not this case. And that is the point which Mr. Justice Trower, in our submission, rightly recognised. Because the appellants in this case are not challenging the authority of the individuals who are the directors under Turkish law of Koza Altin. Those individuals are the directors.
But are they not in effect saying, well, they should not be recognised as directors in England because their authority derives from a judgment which the English court won't recognise?
That is what they are saying. But in our submission, that is raising, with the greatest respect, an entirely bogus question, which simply doesn't fall within the concept of recognition of foreign judgments or foreign legislation at all.
Well, you mean that's just labelling, isn't it? I mean, the substance of the argument is that they don't have authority because their appointment ultimately derives from a corrupt judgment of the Turkish court.
But what is common ground, and it may be important to look at it, my lord, is that it is common ground that under Turkish law, which is the law of Koza Altin, under Turkish law, they are the directors.
They are, so far as Turkey is concerned.
Yes.
I mean, taking it by stages, you say, well, there's no doubt about Koza Altin's rights as against Koza, and that, as I understand it, is relevant for our purposes. Stage two is, are these individuals entitled to cause Koza Altin to exercise those rights? And you say, well, you can break that down into 2 points. One, are the directors entitled to cause Koza Altin to exercise those rights? And I don't suppose there's any real dispute about that in some sense. And then you say, well, there's no doubt that these people are the directors. But that seems possibly to miss a point, which is, are these individuals entitled to cause Koza Altin to exercise Koza Altin's rights in circumstances where their authority derives from a decision of a Turkish court, which it said the English courts should not recognise? So that in the eyes of the English courts, these individuals are not directors.
Lord, obviously that is the way Malone tries getting the issue in front of the court. But you can't raise a supposed question of recognition of a foreign judgment in the abstract. Questions of recognition can only be raised for the purpose of determining a legal issue or a factual issue that arises in the English proceedings. That's what recognition means. It means giving legal effect in English proceedings to a ruling of a foreign court, whether by way of res judicata or by way of a judgment in rem. There is no issue in these proceedings for which recognition is relevant, because there is no challenge to the authority in this jurisdiction.
But there is.
Well-
It's accepted that Koza Altin has these rights. It isn't accepted that your clients are in a position, so far as the English courts are concerned, to cause Koza Altin to exercise those rights.
Well,
And that really is what the case is about, as far as I can see. It's not about Koza Altin's rights. It's about whether
But the people who lie behind Koza Altin,
well, my lord, when you
as
say
it now is, I mean, that's the point.
Lord, when you say what is the case about, why is any dispute happening in this jurisdiction?
Because you
Because
issued 303 and 305
Exactly.
notices.
Which is the exercise by a limited company of rights that arise under English company law, section 303 of the Companies Act.
But
That-
if it were the case that, I mean, in a sense, that's what the judge is discussing in 92, isn't it? That you could have a situation where somebody who was purporting to act on behalf of a shareholder was not in truth authorised to act for whatever reason.
Yes.
And it would be perfectly possible for someone in the position of these claimants to raise that issue.
But that isn't the issue they're raising. They're not raising the point that as a matter of Turkish law, which is the applicable law, the individual directors aren't the directors.
But
They are asking you to take an anterior point. Or did you do that? I mean, they're asking the English court to entertain.
They're saying to this court, these Turkish directors, accepting that they are the directors as a matter of Turkish law, but the way in which they've been appointed is a corrupt one, and therefore you, the English court, should not recognise their status or their authority. And the route by which they do that is by saying, well, this all derives from a judgment, and the English court shouldn't give any credence to it.
Absolutely, my lord. We're entirely agreed as to what the words are on the page in relation to.
Which is
the
why I said
claim.
it's all a question of labelling, really. I mean, you make your point about recognition of a foreign judgment, which I fully understand, but I'm not sure that really addresses the nub of the point that's made against you.
Well, with respect, it does, because, as we say, the only validity that can be given to a request to the English court not to recognise a foreign judgment is where that is being done for some purpose in order to determine an issue that needs to be determined here. The only question, I mean, at the starting point, the question is, do these section 303 and 305 notices work? One question is whether they work as a matter of English company law. The other issue which Malone and Friends clients have been trying to raise is that they don't work because they aren't notices served by Koza Altin. But in order to make that case, they are not challenging the authority of the individual directors of Koza Altin because they have no basis under the applicable law to do so. What
I'm
they
sorry, I mean, that I think is where Mr. Scott would come in, because he'd say the whole thrust of his case is that he is challenging the authority of these directors.
He's
saying
not.
they've been appointed corruptly.
What? No, he's not challenging the authority. They derive their authority under Turkish law. He's not challenging their authority. What he is saying is they do have authority under the applicable law, but we're going to ask the English court to ignore that.
Can I test the limits of what you're saying? Suppose that there were a company incorporated in a country which by misfortune, now had an irredeemably corrupt system. Under that system, where the judges were routinely utterly corrupt, taking bribes, an order had been made by a judge who had taken a bribe, appointing someone as the director of that company. You say, well, once under the law of the place of incorporation, he is a director, so far as the law of that country is concerned. That is that. The English court has no interest in the matter any further.
It doesn't. It doesn't have any interest in that, because the question of recognition only arises if somebody in proceedings here is seeking to rely on a ruling or legislation in another jurisdiction in relation to a dispute that needs to be determined here. There is no dispute here as to who the directors are. So what my learned friend, with the greatest respect, is trying to do is to, well, I mean, in substance what he's trying to do is to turn a very narrow point of English company law about whether or not he's got a golden share that works. He's trying to turn that dispute into a judicial inquiry by an English trial judge into the rule of law in Turkey. And that's actually what this case is about. The issue of English company law and whether or not the golden share trumps the ordinary shareholder's right to remove directors is an issue that could have been resolved years ago. The only reason we are now in the Court of Appeal for the 4th time, having had a trip to the Supreme Court once already, is that Mr. Ipek doesn't want that issue to be determined. He wants to keep these proceedings alive, partly because he has de facto control over Koza Ltd, and partly because he wants to use the proceedings as a platform for ventilating what he wishes to ventilate in relation to his allegations against the Turkish state. That's actually what is going on in this litigation.
That may be part of his motive. I follow that, but if he's entitled to it, he's
No,
entitled to it.
I quite agree.
I quite here nor there.
No, I think
This court has recently reaffirmed that, other than in cases of bad faith or fraud, motive isn't relevant.
No, I entirely accept all of that, my lord. It may come into the argument when we get to abuse right at the end. But we'll, for the purpose of determining the hard point of law, I agree. It is not a relevant point. But what is a relevant point, as I say, is that with the greatest respect, a litigant in proceedings here cannot raise in the abstract a debate about whether or not a foreign judgment should be recognised. The question of recognition is a concept that captures the process by which an English court is invited to give legal effect here to something that has been decided in a foreign jurisdiction for the purpose of determining a dispute over a legal right or obligation here. There is no dispute here as to who the directors are. The sewer judgment, let's assume that it is the fons et origo of everything. The sewer judgment determines that. There is no dispute that under Turkish law, and it may be convenient just to remind ourselves of what Mr. Justice Trower found on this and what is not appealed. So just looking at para 39 of his judgment, page 112. He says it's common ground that there has also been a number of further changes in the identity of the directors of Koza Altin since the SDIF took on the role of trustee, the most recent of which occurred by a decision of the SDIF on the 5th of November 2020, as a result of which the board of Koza Altin came to comprise the individual defendants in the 2021 proceedings. Koza Altin's expert evidence makes plain that, as a matter of Turkish law, the individual defendants are the directors of Koza Altin. This is not contested by the claimants, nor is it contested that Turkish law treats court decisions as being valid and effective until set aside, and none of the decisions relating to the appointments in the present case, including the sewer judgment, have been set aside. So there is no dispute in this court as to who the directors of Koza Altin are.
I mean, just rehearsing what probably is the same point again. I mean, and prior to the sewer judgment, the directors of this company, Koza Altin, were Mr. Ipek, members of his family, people associated with the family.
Yeah.
The reason why you claim to be entitled to represent Koza Altin is because of the sewer judgment and subsequent events, which doubtless you'll come on to. But were Mr. Ipek now to say, well, I am to be treated as a director, you'd say, no, there's a sewer judgment. And of course that's recognised in Turkish law. But it doesn't follow that we should be recognising it.
No, well, with the greatest respect, well, so I don't feel I've got across the concept that on which we submit Mr. Justice Trower decided this rightly. Which is
the
the-
most sensible course is for us to break now. I could have another go at it in the morning.
Well, I'll try and find a different way of putting what I think I've already
It
put.
just
but
occurred to me that probably 4:15 was the right time to stop, and I didn't want to stop you before you had another go at us.
I'm grateful.
I think it would be helpful to regroup in the morning now, Mr. Crowe, unless you feel that we're in danger of not finishing.
Oh no, to be honest, I think we had agreed a timetable under which I wasn't assuming to be
Well,
saying
I
anything
thought
today anyway.
because
So
of court's commitments, we couldn't start till 12:15.
no, I don't think that from my part.
Do we
I
need
don't
to
think-
start at 10 tomorrow?
I don't believe we do need to. No.
No. Right, well, we'll say 10:30 tomorrow morning then.
I'm right.
Very good. Thank you very much.
Thanks very much, ladies and